as restrictions begin to relax across the country, businesses are reopening under new strict rules. Now, this is sparking a fresh set of questions about the rights that employees and employers have in the wake of COVID-19. To answer some of them, we're joined by employment lawyer Lior Samfiru. Lior, thank you so much for joining us as always. So many questions that so many people have across this country. Let's begin with one. Do employees have to return to work if they're asked to? Or can they continue to work remotely?
That is probably the main question I've been getting as well, Anthony. So here's how that works. As long as the employer meets all the health and safety requirements and guidelines that the government puts forward, as long as all of those are met, an employee is required to go back to work. The employee may still feel unsafe, and I understand that, and that could even be reasonable. But despite that, they have to go to work. And if they don't, the risk there is that they may be deemed to have resigned their job, as well as potentially lose the benefits from the government. So speak to your employer if you don't want to go back to work something up, because otherwise, yeah, you do have to go back to work.
Expand on the issue and the questions that people have, whether it is safe, because some people may be anxious about that. They may feel it is an unsafe environment, but what obligation do they have? And, what rights do they have effectively?
Well, keep in mind that the government has outlined what can be open, what cannot be. And for those businesses that can be open, they've outlined exactly what needs to happen. Social distancing, number of customers that are allowed in the store, etc. So those guidelines have to be followed. Now, for employees that may not know what guidelines have been implemented, they can, and in fact, they must ask their employer, what have you done? What have you done in order to ensure my safety? There is a fundamental obligation that every employer has to keep their employee safety, and it's okay to ask that question. And if an employee doesn't get a response, or if an employee feels that the response is such that the guidelines are not met, an employee does not have to go to work. So ask that question, get the information. Only then can you determine if it is in fact safe to go to work.
Can you be forced back to work if you don't have childcare?
So the governments across the country have said that one of the ways individuals can be off work is if you have children that are now at home because there's no school. So if you have a school-age child that is not at school, you can stay home legally and care for that child. That means you cannot be let go. And it then also, of course, means that you can continue receiving benefits. So you have to have that child, let your employer know. The other category of people that can stay home are those that have a medical condition where their doctor says they must stay home. So if you have a doctor's note that says you have to stay home, it's not safe and proper for you to go to work, that will allow you to stay home as well.
What about going back to a modified job? Can an employer force someone to go back to perhaps, lesser hours or a modified job in some form?
That's been happening quite a bit, Anthony. Employers calling employees back to work on either lesser jobs, as you said, less hours, less pay, 50%, 75% pay. An employer does not have the right to unilaterally change terms of employment. That means an employer cannot actually decide they're going to pay employees less, even if there's a good business reason for it. Now, the fact that I said they can't do that doesn't mean that there's a way to physically stop the employer. What that means is that the employee would have the right, if they so choose, to treat that change as a constructive dismissal. That means they would leave with severance. So that is an option that employees have. At a minimum, I suggest to employees, if you're going to accept a pay cut, a temporary one, make sure you send a note to your employer telling them it's only temporary. I'm only agreeing to it on a short-term basis. The fear here would be that if your salary doesn't get increased back to its normal levels, if you don't send that note, you may not have recourse.
Yeah, the key is to have it in writing, isn't it? I want to ask you about mandating temperature checks, for example, or other types of medical testing, if that does happen. Can an employer force that?
So the general rule right now is that, yes, an employer can require an employee to undergo a temperature check so long as it's a non-invasive test, and so long as that information is not stored, recorded, or shared with others. It should only be used for the purpose of determining whether someone has the virus or poses a risk to others. So yes, that is appropriate, and an employer can say to an employee, if you're not going to go through the test, then we can't allow you to be at work. Of course, the test, again, has to be non-invasive and done privately, not in front of others. But yes, an employer is allowed to do that.
Now, this is, I don't know how much time we have, but what if an employee informs their employer that they've come in contact with someone who has COVID-19? Does that individual have any rights to get paid? Because normally you'd be self-quarantined as a result of that. What rights do you have?
Yeah, if you're not able to work because you're self-quarantined, then unfortunately you do not get paid by your employer. You would qualify for government benefits, but the employer does not have to pay you unless the employer is the one that makes the decision for no reason that you shouldn't be at work. But if you have to be self-quarantined, no, you don't get paid by the employer, but there are benefits available to you.
All right, Lior, so great to talk to you as always. So many questions, so many answers. We appreciate your time. Lior Samfiru, employment lawyer.